Hi, everyone, and welcome to another episode of Legal Tings. Today, we're talking about basic information about the divorce process in Singapore. What exactly is the divorce process in Singapore? In Singapore, divorce is a two-stage process for both contested and uncontested divorces. The first stage only involves bringing the marriage to an end by terminating the union and the relationship. During this stage, the court will first decide if there's enough evidence or proof that the marriage has broken down irretrievably. The second stage, on the other hand, involves the handling of the remaining ancillary matters between the couple after the marriage has already been terminated and dissolved. During this second stage, the court will then make decisions to specify the terms regarding the matrimonial assets, maintenance for the wife and children, as well as child custody issues. What are the basic requirements for getting a divorce in Singapore? To qualify for a civil divorce in Singapore, you or your spouse must first qualify under the Women's Charter in the following ways. Number one, you must be domiciled in Singapore at the start of the divorce proceedings, or you have been habitually resident in Singapore for at least 3 years before the start of the divorce, and you must also have been married for at least 3 years, unless the person filing for divorce has suffered exceptional hardship or exceptional, unreasonable, and cruel behavior. These requirements may not be applicable to you if you were married under Muslim law, and different qualifying criteria will apply if you want to get a divorce under Muslim law instead. What do you need to show the irretrievable breakdown of a marriage, and what exactly are the grounds for divorce in Singapore? The only legal ground for divorce in Singapore is that the marriage has irretrievably broken down, and the ways to show and prove this are listed under the Women's Charter. First, adultery, and this means that your spouse has committed adultery, and as a result, you feel that you cannot tolerate living with him or her anymore. Second, unreasonable behavior. This means that your spouse has behaved in such a way that you cannot reasonably be expected to live with him anymore. Third, desertion. This means that your spouse has deserted you for at least 2 years. And finally, fourth, separation. And this means that you and your spouse have been separated for at least 4 years, or 3 years if both of you consent to the divorce. If you and your spouse have children under 21 and are unable to agree on the legal grounds for divorce and all ancillary matters, then the both of you will need to be prepared to attend something called a mandatory parenting program, which aims to help divorcing parents make informed decisions that prioritize their children's needs and well-being. What happens in the first stage of a divorce? In stage 1 of the divorce process, relating to the dissolution of the marriage, the person who intends to file for divorce first will need to file and submit various court documents, including something called the writ for divorce, as well as pay relevant filing fees in the family justice courts to start the divorce process. If you're filing the writ and starting the process, you'll be known as the plaintiff in the case, and your spouse, who will be responding to you, will be known as the defendant. After the writ for divorce and the accompanying documents have already been filed in court, they must then also be served on or delivered to your spouse. He will then have 8 days to decide whether or not to contest the divorce or the ancillary matters, or both. What happens if your spouse chooses to contest the divorce? If he chooses to contest the divorce, he must first file something called a memorandum of appearance, as well as then later on a defense to acknowledge his participation in the court proceedings. The memorandum of appearance must be filed within 8 days after the writ for divorce has been served, and the defense must be filed within 14 days from the deadline of the serving of the memorandum of appearance. And altogether, your spouse will have 22 days to file and serve both the memorandum of appearance as well as the defense. Alternatively, if your spouse wants to give his own reason for the divorce or other claims on the ancillary matters, he must then also file a defense as well as a counterclaim within the above timeframes instead of only a defense. To try to reach an amicable settlement via mediation with your spouse, you can also request for something called a resolution conference with a judge of the family resolution chambers or a counseling session with a court counselor. If both you and your spouse are unable to agree on the reason for divorce on your own, the case will then be assigned to a judge to handle the case and to decide if there's enough proof that the marriage has irretrievably broken down. What happens if your spouse chooses not to contest the divorce? If your spouse chooses not to contest the divorce but wants to give his views on the ancillary matters, he must still file the memorandum of appearance to say which issues he has a particular view on. If the court is satisfied that the marriage has irretrievably broken down, it will then grant an interim judgment ordering the marriage to be dissolved. The case will then move to the ancillary matter stage of the divorce proceedings. What happens in the second stage of a divorce? In stage 2 of the divorce process leading up to the court making decisions relating to ancillary matters, you and your spouse must file your affidavits of assets and means to disclose all your assets and liabilities, income, and expenditure. And if the net value of your matrimonial estate is more than $1.5 million, then the case will be transferred to be handled in the High Court. After you file the affidavits, a hearing date will be scheduled for the court to decide on the ancillary matters, meaning things such as the division of the matrimonial assets, the amount of spousal or child maintenance, or how child custody issues should be handled. Although it's always possible and cheaper to apply for a divorce in Singapore on your own and without engaging a lawyer, it's important to know that the court will still require you to meet the same standards as lawyers in terms of conducting court proceedings, meaning in terms of completing and submitting the same type of court documents and presenting your case and information to the court clearly and in detail. The Family Justice Courts is also unable to give you advice or suggestions on how you should or should not conduct or present your case. And that's why it may be a good idea to at least speak to an experienced divorce lawyer to properly understand your rights and options first. So now you know. If you've enjoyed listening to this and would like to hear more, subscribe wherever you like to listen to podcasts and follow me on TikTok and Instagram. And remember, it's not rocket science, it's just legal things.